My name is Lauren Clagett, and today I will be discussing the emergency laws as they relate to building inspectors in Prince George's County, Maryland. This presentation will analyze what are the potential consequences if a building inspector does not take appropriate actions during an inspection. I will also discuss how we can improve the laws for both the safety of the citizens and how we can protect those who enforce these laws. However, before we begin, I would like to share a short video of an emergency response at a damaged building.
This is a sign of a three-story apartment building that apparently the wind damaged enough where the wall collapsed, exposing. We see some building inspectors here inspecting the damage. Obviously, it's quite significant.
That video was filmed during a 2018 emergency response. I was the inspector on the far right. The wind damaged 11 buildings and an apartment complex, and over 600 residents were evacuated. That event was an example of a proper emergency evacuation. This presentation will break down the laws into three sections: the building code, the liability on ordinary inspections, and finally any special conditions on emergency responses. By combining these three unique factions of law, I will come to my conclusion of the potential criminal and civil consequences the inspector could face. I will conclude this presentation with recommendations on how to improve the current emergency laws as they relate to the building code. The Prince George's County Building Code is found in Subtitle 4 of their ordinance. It is primarily based on the model codes created by the International Code Council, the ICC, and the National Fire Protection Association, the NFPA. However, this presentation will only concentrate on the emergency laws found within Subtitle 4 of the Prince George's County Code, the unsafe structure, and the emergency measure sections of the subtitle. The unsafe structure allows a building inspector to declare a building as unsafe and mandate the owner to make repairs. This is different from the emergency measure clause, which allows the inspector to vacate if there is imminent danger of the building collapsing or if the building endangers life based on the building inspector's opinion. This means there is a potential for an inspector to declare a building as unsafe, but not to enforce the evacuation clause of the code. These laws are currently vague. The definition section does not include definitions for unsafe condition, imminent danger, or endangers life. There has not been judicial review regarding these specific laws. However, based on the Supreme Court case Chevron and persuasive cases from other jurisdictions, we can speculate how a judicial review would conclude. Chevron has set the precedent of accepting the agency's interpretations if their actions are reasonable when the law is vague. In Indiana and Vermont have both had cases where the courts upheld the agency's actions when the governmental entity enforced their unsafe statutes. Now that you have a basic understanding of the building codes, we will analyze the consequences if an inspector does not properly enforce these codes. As a hypothetical case, assume the inspector went to a damaged building but opted not to enforce the emergency measure clause to evacuate the building. Unfortunately, a secondary incident occurred which resulted in the harm of a person. The inspector could face potential criminal and civil liabilities. There are no known cases in Maryland where an inspector has been charged criminally due to failure to take proper actions during an inspection. However, my research has concluded that more than likely, reckless endangerment would be a criminal charge that a state would pursue if somebody died or was seriously harmed. The precedent has been set in Maryland that a defendant can be charged if the defendant failed to act on their duty, and a government official can be charged if they fail to fulfill their duty. The state would need to prove all 5 elements, which includes owing a duty to the victim. If the inspector is sued civilly, it will most likely be for negligence. This has occurred recently when a third-party inspector was sued after a little girl was electrocuted at the MGM Casino at the National Harbor in Maryland. In order to prove negligence, the plaintiff would need to prove all 4 elements. Unlike the third-party inspector at the MGM electrocution case, government employees are protected by a well-known legal concept of qualified immunity. This protects employees from civil ramifications when they take actions on behalf of the government. In the Pearson case, the Supreme Court stated qualified immunity is needed to shield officials from harassment, distraction, and liability when they perform their duties reasonably. However, like all laws and judicial precedents, there is a limit to these protections. The Supreme Court allows a person to sue a government official. It has since been expanded in the Casilla case to allow government employees who break the law or are simply incompetent to be sued by those they have wronged. There is currently a state law that grants civil immunity to municipal employees. However, the Prince George's County law only protects employees from financial liability if they are acting within their capacity and without malice. A common element between both a successful criminal case and a civil case is the element of having a duty. Therefore, does duty exist simply because a building code exists? In 1991, a court in Maryland answered this question. The court concluded that for duty to exist, it has to be expressly created in the statute. Therefore, since there is no duty, there is no negligence. Finally, we'll discuss the laws and liabilities that apply when responding to emergencies. Maryland has upheld the same standard for over 200 years regarding government officials taking discretionary actions. The courts allow employees to use their training and experience to determine the proper actions. The court has upheld if employees' actions are discretionary, they are covered by qualified immunity. Next, we will discuss if there is a duty to act during an emergency. In the state of Maryland, there is no duty to act when someone is in trouble. However, when someone is employed by the government to take appropriate actions, this defense is limited. The court dismissed qualified immunity claims in the Cooper case because his actions were deemed negligent. However, not all positions require actions during an emergency. In the Fried case, the court analyzed if a dispatcher owed a duty to care based on the virtue of their position. The court concluded there was no special relationship between the dispatcher and the victim. Instead, the dispatcher owed a duty to the community as a whole. Therefore, the dispatcher did not owe the victim any action during their emergency. Now that we understand the laws, we can now analyze what would occur in a hypothetical case. What would occur if a building inspector failed to evacuate a damaged building and someone was injured or died because they failed to enforce the emergency measure clause in the Prince George's County Code? If the state pursued criminal charges, it would most likely be for reckless endangerment. However, the state would have trouble proving the duty element. It has been established building inspectors does not need to enforce a code just because the code exists. Their job is discretionary in nature and the law is vague. Therefore, the courts would most likely rule in favor of the inspector unless there was gross negligence or malice. Next, the inspector could be civilly sued. There is no statute that protects them even if their actions are reasonable. There is limited protection with qualified immunity common law. Regardless, the plaintiff would still need to prove there was duty owed to them in order to be successful. This conclusion can be hurtful to the citizens of the county. In order to hold employees accountable, duty should be established. This leads us into my recommendations on how to improve the emergency building laws. There is currently no national standard when it comes to qualified immunity and the definition of duty involving building inspectors. The Supreme Court would need to hear a case to establish rules the lower courts can adhere to. I recommend creating duty when building inspectors respond to damaged buildings, so they can clearly be charged with a criminal statute if their inactions caused a death or serious injury. Next, the county code should define the verbiage better. Would a faulty sprinkler system be enough to justify imminent danger? Would lack of water justify an unsafe condition? Without clear guidance from the law, the agency will need to fill in these questions. Lastly, there needs to be more protections for building inspectors from civil liabilities when they are acting reasonably. A very simple solution would be to create a law that offers the same protections that is currently granted to other agencies within Prince George's County government. Subtitle 11, the Fire Code, Subtitle 6, the Emergency Management Code, and Subtitle 13, the Housing Code, have a code section that protects the employees who enforce these specific code sections from civil liabilities. In fact, Subtitle 13 expands this protection even further by guaranteeing the employee legal representation. However, Subtitle 4, the Building Code, offers no immunity against civil suits to those who enforce the emergency measure and the unsafe structure laws. Building inspections are complex. Employees make decisions with discretion. They deserve more protections as they respond to dangerous situations. They deserve immunity as long as they conduct their inspections within reason. But there should also be consequences if they act inappropriately. Thank you for your time, and you are welcome to email me if you have any further questions.